So welcome to all to our Lexis webinar, where we are going to discuss the recent Court of Appeal decision in James Churchill against Merthyr Tydfil County Borough Council, which was handed down on the 23rd of November. The purpose of this webinar is to consider whether ADR is no longer an option, but set to become a compulsory part in the litigation process, and how practitioners should integrate ADR into any claim timetable. We are very happy to be joined by a prestigious panel today in this subject, including Iain Wightwick, who is a barrister at Unity Street Chambers, and most importantly, acted on behalf of the Council in this decision. Rebecca Warder, amongst all your different hats, Deputy Chair at the London Chamber of Arbitration and Mediation, and Anna Gilbert, Counsel at Hausfeld and Co. But Iain, Anna and Rebecca, I shall let you introduce yourselves.
Well, thank you very much indeed, Neda. And I will try to do so briefly, but it's very difficult for a barrister, particularly if you give me 3 minutes, I'd normally take 15. So I'll try to keep it down. I am ancient in that I was first called to the bar in 1985, so I've been going for it for nearly 40 years. I'm a junior barrister practicing in Bristol, and I specialise in property law, especially landlord and tenant, and in the landlord and tenant field, particularly working for social landlords, so housing associations, local councils, and for some big institutional landlords. I defend an awful lot of housing conditions claims. That's what used to be called housing disrepair claims, and that is how I got into Churchill, because about 20 years ago, I worked for Merthyr Tydfil, and they came to me with about 120 housing disrepair claims. They said, Iain, can you defend these? And I said, yes, why don't we run the argument that I'm running elsewhere, which is that these people should not be suing Merthyr unless and until they've tried the internal complaints process, and it has failed to give them what they want, essentially, to satisfy their wants and needs. So we ran that argument before the marvellous District Judge Singh back in 2003, and he agreed. And so he dismissed the 12 test cases that we'd put before him. And we had agreed that if the judge dismissed the 12 test cases, then all of the cases would be withdrawn. And the claimant solicitors had to withdraw all 120 claims. That had a catastrophic effect on those solicitors, because back in those days, there were a lot of firms which didn't have legal expenses insurance, and they were personally liable on their firm's debts. So I know that other local authorities, I'm not sure whether Merthyr did, but other local authorities in the area put the solicitors into liquidation and bankruptcy. And so for 20 years, South Wales wasn't really troubled by housing conditions claims. And then in 2022, the same solicitor that had instructed me back 20 years before came to me and said, oh, Iain, we've got this Japanese knotweed claim. And I wondered whether you might want to see if you can deal with it in the same way that you dealt with the housing claims, because we've got an awful lot of these claims coming in, and I've checked with my friends in other local authorities, and we are being inundated with claims saying, well, your knotweed has spread from your land to ours. So that's how I ended up doing Churchill, and I did it at first instance, and then I did it on appeal, and I'll talk more about that when everybody else had a chance to introduce themselves. But anyway, it's Iain Wightwick, by the way, impossible to pronounce and impossible to spell, so that's me.
So I'm Anna Gilbert. I practice at Hausfeld and Co, as Neda mentioned, as counsel. We're a law firm based in London. We practice in a variety of commercial disputes, and also the firm has a competitions practice and a group action practice as well. I practiced in London for most of my career, but I have also practiced in the Cayman Islands and very briefly in Australia. But I'm very much an English solicitor, I think, culturally. In my role, I represent commercial clients, high net worth clients in business disputes, And these are quite broad in range. They include general contract disputes, shareholder disputes, and also complex claims which involve fraud and financial wrongdoing, which is a very broad range. I've also got experience in commercial arbitration, and I'm a member of the Chartered Institute of Arbitrators.
Thanks, Anna. It was great to hear about Iain and your wealth of experience. So I'm currently head of knowledge at Hausfeld, where I work alongside Anna. And in my days of practicing as a lawyer, I operated as an arbitration and litigation practitioner, working mainly on high value and cross-jurisdictional disputes. So with that, wearing that hat, I have a lot of experience of mediation in the council context, but latterly wearing a different hat, also as the Deputy Chair of the London Chamber of Arbitration and Mediation, which we affectionately know as LCAM. And we are an arbitration and mediation institution offering fixed fee mediation with quite an eminent panel of mediators. And we are an independent not-for-profit entity which sits under the umbrella of the London Chamber of Commerce and Industry, mediating both litigation and arbitration cases.
Thank you very much. As I said, we're very happy to have you, and I can see that we are nearly 250 people listening to you, so thank you and no pressure. Iain, shall we start with you? Would you like to introduce the case briefly?
Certainly, I'll do my best to be brief, Neda, although there's quite a lot that I can say about this, so stop me if I go on too long. It's interesting to hear from Rebecca and Anna about the colossal cases in which they've been involved in their practices, because a lot of my practice is in regard to fairly small cases, and in particular housing conditions claims. These cases are often only worth a few £100s in the repairs that are necessary to social housing, but they generate enormous amounts in costs, and I mean enormous compared to the few £100s. So the housing conditions claims, it might be up to maybe £3,000 would be paid in damages in the end, but the costs for each party would be 30,000, 40,000. It's not unusual to see those sorts of sums. And the reason I mention that is because Churchill was no exception. Mr. Churchill owns a property in Merthyr, which is worth about £100,000. So on the low side of property in the England and Wales these days, and he bought it in 2015. He says that in 2016 he noticed that there was some knotweed at the bottom of his garden, but he did not do anything about it for 4 years, and then we do not know why, but we suspect that it was because he saw a Facebook advert. He engaged McDermott Smith, the solicitors who appeared in the Court of Appeal, to sue Merthyr for having allowed the knotweed to go from its embankment into the back garden at Mr. Churchill's home. And that back garden, just to give you an idea of the geography, it isn't even connected to the back garden beside the house, in that there is a public footpath that runs right the way through in between two patches of garden. And so this patch of knotweed is right at the bottom of the second part of Mr. Churchill's garden. I don't know whether he ever goes there, but certainly it is nowhere near his house, and it is not somewhere that's going to do him any harm. And that's quite important because of what then happened. So he instructed these solicitors. They wrote to Merthyr and they said, we're suing you for about 55,000. We are claiming that it'll cost about 25,000 to treat this knotweed, and our clients lost about 27,000, 28,000 in the value of his home. And so Merthyr, luckily, responded by sending the claim to Simon Jones, my solicitor there, who remembered what we'd done earlier with the housing claims. And he wrote back and said, well, hang on a second. Your client's writing to us in 2020, but why hasn't he done anything in the last 4 years? And also, he could just go to the internal complaints process. This is the first thing we've heard of this. So can I recommend you do that? response came back, just as it does in housing conditions claims. No, absolutely not. No, Mr. Churchill's completely lost faith in the internal complaints process because the council have done nothing to stop the knotweed in his property. So Mr. Jones just said, well, if you issue, we'll apply to stay your claim, and we will suggest that it goes through the internal complaints process. Surprise, surprise, they issued a very, very long time ago now, in August 2021. And it's worth thinking that if the knotweed had been treated when Mr. Churchill eventually went to solicitors 3 years ago, it would be well on its way to being dead forever now. It takes about 7 years, and sometimes it's very difficult to eradicate it completely. But generally speaking, it would be well on its way to being eradicated. So Mr. Jones also said, well, I've checked with our knotweed eradication team, and it will cost them about £250 to treat this knotweed for as long as it takes to eradicate it completely. So not £250 a year, but £250 in total over the course of whatever, 5-10 years. It didn't stop them from issuing the proceedings, and the claim was framed as quite a large claim, well above the fast track limit. They then said, well, we want it listed in the multi-track, and here's our precedent H, which is a list of all the costs they're going to incur, and it was about 120,000 plus VAT. So again, my solicitor wrote and said, well, hang on a second, this is crazy, because here you are saying that it's going to cost all this money and we're offering to treat it for nothing and forever. So would you please reconsider? And if you go through the internal complaints process, they'll look at how much in terms of diminution in value you might be entitled to. It did no good, and so Simon Jones had to issue this application to stay. It went before a very well experienced and very competent deputy district judge in Cardiff, who said, well, I agree entirely with what Merthyr have said. This is a complete waste of time in terms of a case, and it really should go through the internal complaints process before it goes any further. But I've been taken to the decision in Halsey against Milton Keynes Area Health Authority, which coincidentally was decided at almost the same time that I was running this argument back 20 years ago, and in which the Court of Appeal has said, well, actually, it's an interference with the Article 6 rights of an individual to stop a case from running. And the only way that you can penalise someone for not using ADR is by making them pay the costs at the end of the proceedings. Well, you'll all know how hopeless that is as a disincentive, because even if you get to the end and you win, well, you're not going to get any more than you would have got if you lost. In other words, you'll get your costs normally. And if you lose, then a lot of judges say, well, Mr. Wightwick says that you should have gone through an alternative dispute resolution process, but after all, Mr. Wightwick's side lost, and therefore I'm going to make them pay the costs. So it was hopeless. ADR was not being used anything like as frequently as it should be. And we went direct to the Court of Appeal, in the sense that we asked the leapfrog process to be put in place, and we made an application to His Honour Judge Harrison in Cardiff, who luckily seized the point immediately, and he said that yes, this was obviously a point of general public importance, and it was almost certainly the sort of thing that the Court of Appeal would like to deal with directly, and there was no point in having a county court appeal. And that's important both in terms of the costs, but also just in terms of timing, because we thought at the time, this is back in March through to August 2022, that we would be soon in the Court of Appeal and we would have a decision that we could then use in other cases. How wrong we were. It was a very long time in the end before it came to the hearing of November last year. That's because there were 7 interveners, and there were 7 interveners because the effectively the administrative judge who arranged how the case would proceed in the Court of Appeal invited interventions, and it was publicised fairly heavily, and we ended up with Bar Council, the Law Society, 3 alternative dispute resolution bodies, the Housing Law Practitioners Association, which is the claimant's body for housing conditions claims and other claims, in fact, and the Social Housing Lawyers Association, who are the social landlords body, and they represent social landlords in housing matters. So we had, was it 4 or 5 silks in November, and about 8 juniors in the Court of Appeal. It was a packed courtroom, and we spent 3 days arguing about whether people should be allowed to just press on with litigation, or whether the court could say, no, stop, you, Mr. X, will have to go through some form of alternative dispute resolutions. So you will, I hope, have either seen the judgment or you can get access to it. It's online. In fact, so are the proceedings. You can see the Court of Appeal in action on YouTube. If you just Google Court of Appeal Churchill against Merthyr YouTube, you will see that the whole thing was recorded and transmitted live. And it was really interesting. I have been in the Court of Appeal a few times before, but on this occasion, I saw some of the greatest advocates of our time. So if you want to see some brilliant speaking, you just have to log in and see those silks performing, because it must have been really difficult for the 3-judge court at the Master of the Rolls, Geoffrey Voss, and the Lord Chief Justice, Sue Carr, and the head of civil justice, Colin Burse. So it was a heavyweight, a heavy-hitting Court of Appeal, and they must have had a really difficult time doing the judgment, because although they used a lot of what we had said, they clearly thought about it independently, and particularly because we were effectively ambushed by a 3rd skeleton argument from the respondent, just as the appeal was proceeding. I think it was on the 2nd day, when they raised other arguments that had not been previously considered, and everybody was taken by surprise, and we were all running around trying to do something about it, but effectively it was left in the hands of the judges to work out how to steer through this minefield of authorities. There were 900 pages of authorities. It was hideous. And the judgment, as you'll see if you look at it, is incredibly cogently argued. Geoffrey Voss and his fellow judges dismissed the idea that Halsey could stop people from using ADR compulsorily. He said that the remarks that had been made were obiter dicta. That means that they weren't part of the rationale of the decision. And therefore, they were then going to consider the whole thing afresh, and they did. And they went through dozens of cases, and they said, well, effectively, provided it doesn't interfere with someone's right to litigate fundamentally and stop them from doing so, and provided it's proportionate, then a non-court-based resolution procedure could be forced upon one of the parties to a claim. So it's hugely important for everybody involved in litigation, but particularly for public bodies, because the Court of Appeal had already said in Howell against Plymouth City Council, and that was Lord Justice Wolfe, that people who sue public authorities really should keep an eye out for any internal complaints procedures that that body might run, and use that procedure. So that was already established as a principle of law, and now this second decision has has meant that certainly a lot of my clients will be saying, well, actually, before you sue us, can you please complete the internal complaints process? And that does not involve lawyers on either side. So it's a hugely important decision for litigators, and it could change the face of the next few years of litigation. I hope I haven't gone on too long, but Anna, perhaps we can hear from you on cases in which alternative dispute resolution might not be forced on the parties and the sort of situations.
Thank you. Thank you, Iain. That was so interesting. And I think it's so interesting to hear how a bit of knotweed in somebody's back garden could be the catalyst for this sea change. And now here we are all talking about ADR in a very different way. And the client perspective, of course, is that generally clients want their disputes to be resolved as quickly and efficiently as possible. There are some unfortunate exceptions, but really I see this decision as bringing practitioners' focus back to recognizing what is the most appropriate way to resolve this dispute and whether or not really the court forum initially is the right place for it. There are some cases where a client may feel that actually ADR is not going to be appropriate. And I think it's really key for practitioners also to be thinking about those other examples where it possibly isn't appropriate or it might not work. But one of the first points to consider from Churchill is, of course, this case isn't about solely mediation. It wasn't a mediation process that Iain was discussing. It was another process which was outside of the court forum. So I think that's the first important takeaway, is not to too narrowly limit the remit of what this case could mean. It's not about necessarily parties being forced to stay proceedings and having to go to mediation, but certainly it is very much about the court having the power to stay proceedings where some other thing, which might be mediation or it might be some other process, is going to be the appropriate route to at least explore whether the case can be resolved. There was a very important caveat in the court's decision, which is that it won't be appropriate and the court should not exercise its power to stay proceedings if this ADR process is going to impair the claimant's right to a judicial hearing, or where the ADR process is not proportionate to the legitimate aim of settling the case fairly, quickly, and at reasonable cost. And I think that wording creates a very helpful roadmap for practitioners to consider when might ADR not necessarily be the right thing for this case. And an example that springs to mind, having dealt with many fraud cases, for example, is where you have a party that is inherently dishonest or suspected of dishonesty. You're not on an even playing field where you might have a defendant that is trying to dissipate assets and is lying about its behavior, and there's an urgent need to engage with the court to lock down assets, to obtain ancillary disclosure orders off the back of an injunction, and then to consider immediately what other proceedings are most appropriate. It doesn't seem very practical to be suggesting in that scenario, let's all have a discussion about alternative dispute resolution. So clearly there are going to be examples like that, which are unfortunately fairly common around the world, where you have a fraudulent party. I would suggest that anyone who is responding to say, let's have an ADR approach, there are probably going to be some very strong reasons to resist that. Rebecca is going to talk in a couple of minutes about the when in all of this, because I think that's a very important factor. And it might be that there's a scenario where disclosure needs to be obtained, assets need to be locked down. ADR is not appropriate at that phase, but perhaps at another phase. Another example where ADR might be very difficult or might not be appropriate is where you have a clear path to a strikeout or summary judgment. It may be that a particular case is very clear cut. And in fact, there's a strong basis for the entire thing to be resolved appropriately using the court's process in a very short period of time. It might be that it's proportionate to do so, depending on the facts of that case. I think it's something to really think about in the mix. I would still say, though, a party might pull the ADR card in those circumstances and say, hold on a minute, before we have our hearing of your application to strike out these proceedings, let's explore ADR. And it's going to be very fact specific whether or not that request is going to be ignored. There's always a cost risk in doing so. It might be a little bit of a risky card to say absolutely no ADR. Might be in those circumstances beneficial to explore some form of ADR, but it doesn't necessarily need to be a full-blown mediation, for example. Another example where it might be difficult or at least complicated procedurally is where you have multi-party proceedings or where there's a group of cases that are being case managed together for a particular reason. So there's an issue common to all of these proceedings, and I'm aware there's quite a large number of insurance claims, aviation claims going through the court at the moment that have different parties. They're all being case managed together. In that type of a scenario, it makes procedural sense to keep the cases on the same track. And arguably, it could be a complicating factor for one party to step out and say, let's explore an ADR process and stay our claim. They then, going forward, will be outside of that procedural timetable. I think that there will be examples of where this instance has arisen and the parties have still decided, actually, we're comfortable with that because the benefit of potentially solving our claim outside of the court process is going to far outweigh the downside of not being in track with these other cases. I think that absolutely can be a benefit, but certainly it's worth considering when you have these procedurally complicated disputes, what the impact will be of stepping out of that timetable and staying your claim. There was a very interesting case recently, which was decided in January this year, where this argument came into play. This is the case of Lancashire Schools, SPC Phase 2 Limited and Lend-Lease Constructions. So very oddly, this case doesn't cite Churchill. I'm not sure why, but it's certainly not referred to in the judgment. But this was a case where there was a compulsory ADR clause in the contract requiring the parties to first explore adjudication before litigating. That wasn't followed, and one of the defendants applied to have a stay of the claim against it so that the mandatory adjudication clause could be followed. And in that case, the court declined the stay and said, no, actually, this is procedurally very complicated. There are lots of claimants. There are various different contracts that are all being dealt with on this particular case management timetable. And it would cause procedural difficulties and disproportionate problems if we stayed your piece. I think this is quite possibly an anomaly. It certainly is a very strange outcome in the context of Churchill, but it's the type of scenario that that practitioners should be thinking about and discussing with clients. And just briefly on that, I think that's an important takeaway, both from Churchill and also from the Lend-Lease case, where the parties did in fact have another process already on the stocks. There was a roadmap for parties to go down another ADR process that was outside of court proceedings. And certainly it's very beneficial to have in your contract some alternative dispute resolution clause or tiered clause, which will give the court a guide to what exactly is going to happen if these proceedings are stayed. Because if you have parties that are at loggerheads, they struggling to agree on a timetable every single step of the way in the litigation, you're having this hot, a debate and a fight, and it's just very difficult. In those circumstances, it can be very, very difficult to arrive at a neatly organized ADR process that's going to suit everyone. having a clause in the contract which sets that out, it certainly gives initially a pathway for the parties to follow, but also it's very helpful for the court to recognize, okay, there's an application for a stay. I can see in the contract the parties have actually already set this out, and there you go. You need to go away and do that for a month and come back to me before I decide your dispute through the court procedure. I'm going to let Rebecca talk about the timing issue. So on to Rebecca.
Thanks, Anna. And I know you've been talking about some of the cases where it might not be sensible to engage in ADR, but I know that in the vast majority of cases, it'd be interesting to see if the panel agrees on this. Certainly my experience, both on the council side and at LCAM, is that the right time for ADR can actually be any time. But I would say that the key is as early as you can, which I think will probably be music to Iain's ears in the context of the experience of the very lengthy process on Churchill as it in fact unfolded. So just looking a little bit at litigation, the pre-action practice direction, of course, says that the parties have to think about would ADR be appropriate right at the very beginning of the case, and actually carry on doing that throughout the case. And the court can actually, of course, ask parties to give them evidence that they have considered ADR. And we know that some of the other pre-action protocols go further with more specific requirements. And that same point on early pre-action ADR was also made very clear in the recent report that the CJC has put out on the pre-action protocols, which came out in August 2023. And that has proposed replacing the current practice direction on pre-action conduct with a new general pre-action protocol, which it is suggested is going to make everyone engage in pre-action dispute resolution, and that there is going to be a default requirement to have a confidential pre-action meeting if the parties can't between themselves agree on the right ADR process. And of course, that's going to be a lot easier, Anna, in the circumstances that you outlined, where there's actually a contractual clause. So the right time to mediate is really going to depend on the particular dispute in question, and that's going to be the same for any form of ADR. And in any case, that is really going to be when the party who is considering that question is feeling comfortable enough that they understand enough about the strength of both their own case and the case that they're being asked to meet. And that means that they're in a position to assess the strength of their position in terms of liability and what a reasonable settlement might look like. So obviously, in some cases, the parties are going to know a lot about the dispute at the outset and enough to feel ready to suggest mediation before you've even filed the claim. But in other cases, they're going to want to wait to the pleading stage because they may feel they don't understand enough about the issues at the beginning. And there will be cases, and I think, Anna, you mentioned some circumstances a moment ago, where people will want to wait for disclosure, because without that, they won't feel ready to say that they understand their position, and they'll want the information that has come out of the disclosure process. So you can see, as soon as we start going through some of these scenarios, what a fact-specific question that is for each case. But while all those questions are going to impact when a particular party is going to feel ready to suggest mediation, and actually whether the other party is going to feel comfortable agreeing to settle, what the case law tells us is that refusing another party's offer to mediate is definitely not something to be lightly undertaken. And I just wanted to say a couple of words on the impact on costs of an unreasonable refusal to mediate, which takes us right back to Halsey, which we discussed at the beginning. And is, in that context, ADR really now not just an alternative, but actually effectively operating as an imposed tool to resolve disputes? So we know the courts have made their support for ADR super clear, and that includes some quite swingeing cost orders, penalising people who have unreasonably refused to mediate, and that can include unreasonable refusal to undertake even pre-action mediation. And one of the things that was discussed in the Halsey case was, can a party say, I have such a strong belief in the strength of my case that it is reasonable for me to refuse to mediate? And that was one of the principles set out in Halsey as a potential circumstance when a party can legitimately say, I am going to reject your offer to mediate. But it's interesting to see the way that the recent case law has moved. So in an interesting case, which is called Philip Garrett Critchley and Andrew Rowland and Solar Power, which is from 2014, the defendants rejected mediation and told the other side that they were confident that in a matter in which our clients were extremely confident of their position, and they went on to say there's no real prospect that the other side's client would succeed, the rejection is entirely reasonable. Well, unfortunately, the court didn't accept that. And they said that that case was a very typical kind of case that you tend to see in mediation and indeed in litigation, where the question that was going to go to the court was there a binding contract? And that was always going to mean a really detailed consideration of witness evidence and documents. And the defendants at that point had absolutely no certainty that that analysis was going to go their way. And so their position on the merits wasn't entirely reasonable at the time they put it forward. And so the court actually made a point, Anna, which echoes, I think, a point that you made earlier, which is the court actually stated that it was a factor in their thinking that no application for summary judgment had in fact been made. So the defendants in that case had also raised the point that it was pointless going to mediation because there was never going to be any agreement. And the court also rejected that contention and said that in most cases, you really cannot say at the outset that the parties are too far apart to reach settlement and mediation. And if they've actually attempted it, that may be something that they can say. But if they haven't, then there really is no factual foundation for that sort of comment. So in fact, in this case, having said all that, the case did go on to settle, and it actually settled after the trial, but before the judgment was handed down, which rather illustrated the points that the court was making. And of course, we know the cost penalties are already there. And in that case, the claimant got their indemnity costs. And the case law on a strong belief in the merits of your position has really moved somewhat over the last couple of years. And it was always, I think, a relatively high bar, but the direction of the case law is tending to make this an even higher hurdle. And there's a couple of interesting recent cases, including Wales and CBRE managed services, where, for example, somebody was docked 50% and 20% of their costs, respectively, for 2 phases of the litigation because they'd refused to mediate. So it isn't really clear at the moment, though, how these cases that we're talking about now on an unreasonable refusal to mediate are going to interact with Churchill. So that's going to be very interesting to watch. But it's definitely already clear that parties who are pushing for ADR, in addition to that opportunity to get costs back or ask for cost consequences at the end of the matter for unreasonable refusal, can obviously ask for a stay, which has been an option. But after Churchill, it's perhaps getting much clearer that that can happen even if one party is very reluctant. So Neda, I think there's a couple of other things you wanted us to talk about, so I'm going to hand back over to you.
Thank you, Rebecca. Yes, well, I think coming back on a point that you have all mentioned and with which I agree is that ADR is a tool, and a tool that is aimed to resolve disputes. And that is really the webinar's title, ADR using the capital A as the appropriate dispute resolution rather than the alternative dispute resolution. So Iain, I think when we discussed the case for the first time, I remember you rightly pointed the fact that it's not just about mediation and but also finding the most appropriate tool to resolve your dispute. And would you like to expand a little bit on that and say what it means in the litigation world beyond mediation?
Yeah, sure, Neda. Yes, of course, it wasn't anything to do with mediation. And in fact, the other side were offering us alternative dispute resolution, but only forms in which they were going to get paid large amounts of money. And I'm used to seeing mediations being run with a mediator's fee of a few £1,000s, and then both parties have barristers and solicitors turn up, and you end up with a £10,000 bill. So put against the internal complaints process, which is free to the claimant and doesn't cost the council that much because it doesn't use lawyers, it doesn't have any fixed formal process, and it can be flexible depending on the nature of the complaint. It is a no-brainer that one should look at an internal complaints process before looking at other forms of ADR. And part of the issue there, of course, is that there is a huge difference between a process which locks out someone's ability to go to court to seek a remedy, such as a binding arbitration, or any other form in which the decision is said to be final, and a form of alternative appropriate dispute resolution where the individual is perfectly free to go to court afterwards. If they don't like what's been offered, well, they just continue with the proceedings or issue the proceedings in the first place. And that's what an internal complaints process is all about. It is merely part of a series of non-court-based methods of trying to resolve a dispute. And because it is free, and because it doesn't end in the result of costs, in the award of costs, then in all probability it has to come first, because otherwise you've run up 5, 10,000, 20,000 pounds worth of lawyers' costs, and the internal complaints process says, well, it's not our job to award costs, and therefore the whole process fails and everybody goes to court just to argue about the costs. So there is a push from the Ombudsman to, certainly in housing conditions claims, to make internal complaints processes more part of the expected reaction conduct. And the recent guidance that the Housing Ombudsman has issued has said that just because a letter of claim is served, it does not need to stop the internal complaints process working. So that is going to result in a lot of landlords who understand how to defend claims, a lot of landlords saying, well, thank you very much for your letter of claim. We'll put that to one side and we will send out a surveyor, and we will do a stage 1 complaint. We will write to your client, and if they are unhappy with what is proposed at stage 1, they can go through stage 2. And if they are still unhappy, they can go to the Ombudsman or they can sue. That's a matter for you. But that's just one area. You know that there are internal complaints processes in many areas of the law in which consumers already have an obligation to use the internal process before suing. So, for instance, in financial claims, in eBay and on Amazon, there are obligatory requirements for people to try the internal process before they go off to court. And it seems to me that social landlords who don't have an obligatory internal complaints process requirement in their tenancy are missing a trick, and they really should change that. And they also need, of course, to look at their complaints procedures and make sure that they are Churchill compliant, for want of a better word, because there are lots of factors in the judgment in which the Master of the Rolls said a court would be interested before stopping a claim, and you need to understand how to make an internal complaints process or any other form of non-court-based dispute resolution process compliant with the requirements that Geoffrey Voss gave. So where does that take us in terms of litigation in the future? Well, two things occur to me. One is that there is another case called Hammond against UCL, in which many hundreds, if not thousands, of claimants are suing UCL for the return of some of their fees. That went before Senior Master Fontaine in July last year, and she ordered a mandatory stay in the face of objections from the claimant's lawyers. She said that she wasn't going to mandate the use of the internal complaints process because they'd raised two issues with it, but subject to those being resolved between the parties, then she might, when it came back to court, actually oblige the claimants to try that process before going ahead with litigation. So it may well work in multi-party actions. We'll have to see about that. And the other is I'm doing an appeal in May in Luton, which has come from a case I did in Reading last year. And on that, we are not leapfrogging to the Court of Appeal, but we are seeking to apply the Churchill guidelines to housing conditions claims in general. And so there will be, obviously, I'll be asking the county court judge to record that it is a decision to which people can have regard. And I can't remember what the process is, but you have to make sure that the judge agrees that it is a case which should be reported, and a case which doesn't form a precedent like a Court of Appeal precedent, but it is persuasive on other county court judges. So we'll see about that. In general, I would hope that certainly my clients are going to be saving many millions of pounds in legal fees, which can go to housing repairs and to providing public services, because you may have gathered that I have a pretty strong view about this and about the necessity or lack of it for lawyers to be involved in a lot of disputes. And sorry if you are a lawyer who might suffer as a result. That's how I think the future of litigation should be, that we should be involved only if it's urgent and in the first instance, and then only if the parties can't use some form of ADR. Sorry, I've talked too long again. Over to you, Anna.
I think some really interesting points, and very interesting to hear about the recent decision, the case involving UCL, where the parties are being required to go away and think about what ADR process they should explore. So I wanted to touch briefly on how would I advise my clients post Churchill. I suppose the pure answer is the advice ought to really be not that different from what clients were previously advised, because we ought to always be advising our clients to find a way to resolve their disputes in a way that's most proportionate and reasonable, and so on. But I think in practice, what I've certainly seen over the last 15 years is quite a lot of interest in ADR, and it became very much a fashionable subject quite some time ago. Lots of discussion about encouraging parties to mediate and what's the court going to do. And for some reason over the years, I've really seen a drop in certainly some attitudes, less of a prioritization of really actively exploring ADR in a way that could achieve its full potential. So certainly this is a positive change, where I hope that practitioners will be refocusing on ADR, and it's going to be more of a priority. I would advise my clients initially, of course, is ADR appropriate, or more accurately, what ADR is going to be appropriate. There might be a rare case where there's an important principle of law, and actually, ironically, Churchill is that case, where I think it was very important for the Court of Appeal to hear that case and to hand down this decision, which now gives a new direction to ADR. So there might be some cases where really it's essential for precedent to be set and it needs to be dealt with. But in most cases, there's going to be some type of ADR that will be appropriate. So I would be encouraging my clients to be proactive about raising ADR. There's some nuance with the when, and that will depend on the type of case. But I think in many instances, it really ought to be as early as possible, subject to the various caveats and exceptions I've already mentioned. I would be encouraging my clients to really think very hard about cost risk. It's always there, but I feel that this decision of Churchill is going to, if anything now, even create more of a cost risk in being obstructive with an ADR process, because the last thing you would want is the court to order that the parties go away, explore ADR, and then it's your client that's been the difficult one that's refusing XYZ detail of the process. So really, the advice needs to be get on with this, make it work as best as you can. I have a little bit of a concern that there might be a culture that develops of going through the motions, where there's an acceptance of, okay, fine, we have to do this and tick this box, and let's send this without prejudice letter, and we say we've gone through ADR without really a genuine engagement. And it will be very disappointing if we see that. But I think perhaps there will be more pressure as well on parties to engage with ADR in a more direct way, and I hope it won't develop into a culture of going through the motions. And also I would encourage my clients that it's very difficult to see in what circumstance is ADR, even if it doesn't resolve your case finally, in what circumstances is it not going to help? Because any scenario where you're sharing information with the other side, you're sitting around the table, you're talking about what you consider to be the strengths of your cases, you're talking about a potential middle ground. It's an opportunity, of course, to learn about your opponent's case, the other party's case. It's an opportunity for the client to really think very carefully about the risks in going through to a full trial. It might be that it's worth it, but I think it's quite important for that thinking to be done throughout the life of a case, or even prior to issuing proceedings. I think Rebecca's got some interesting points about the consultation process, so over to you, Rebecca.
Thank you. And Neda, I can see the time, so I know I need to be brief. So I think a lot of what Anna and Iain have just been talking about is very interesting in terms of thinking about the ADR process itself. And it's obviously very important to have the right flavour of ADR. And sometimes that might be a cost-free process, but sometimes I do think that parties do have a better chance of success if they actually use a neutral in a process like mediation. And very interestingly, the government has very much nailed colours to the mast on mediation, having just confirmed after a wide-ranging consultation that mediation is soon going to be made compulsory for all claims, barring a certain number of categories, which we won't go into today, is probably outside the scope of our discussion, up to £10,000. And they've also made it clear that that might not be the end of the process, because they might extend that to larger claims in future. That's all fairly innovative and striking stuff as far as the civil justice system in England and Wales is concerned. But I think it's fair to say that there does actually seem to be a fair amount of support for it. So at LCAM, we ran a survey jointly with Herbert Smith Freehills last year, and we asked people how they felt about the possibility of the introduction of compulsory mediation. And just under 75% of people who replied said they thought, in principle, it could well be effective. And actually, over 75% of people said they personally were in favour of compulsory mediation and litigation. And on arbitration, it was 80%. So those figures are quite striking, because I think it's fair to say that there have been some concerns expressed by solicitors and by others in the legal profession. So just overall, before I finish up and hand back to you, Ned, I think the direction of travel, both from government and the judiciary, and also from parties themselves, seems to be likely to continue and intensify this trend of increased demand for ADR of all types, including mediation. So it's going to be really important that mediation organisations and institutions are ready to meet that demand. It's going to be important that there are cost-effective processes, and I think, Iain, you made that point, I think, very forcefully and rightly. And it's also going to be important that, as lawyers, everyone involved in the process is alongside the organisations involved themselves, doing that really important role of explaining the benefits to clients and looking at the success rates. And again, we did a survey at LCAM with Herbert Smith Freehills again in 2021, asking mediators to confidentially report their individual success rates anonymously. And that was on arbitration cases, but it showed that the success rates, even for large commercial claims, really are excellent. And just under half of the mediators who replied to us told us that they are actually settling at least 70% of their cases. And another 17% said they were settling between 50 and 70% of the cases that came before them in mediation. So I think, Hannah, that while it's right to caution about a risk of going through the motions, it's really important also to keep our eyes on the prize, because the saving in terms of cost and time for parties is just enormous. I'm going to stop there, Neda, and let you take us back in hand.
Thank you very much. No, that's absolutely fine. I was trying to gather all the questions to ask you maybe, but just before we proceed with the question, I was just wondering whether you would like to just close very quickly that conversation on Churchill. And I think, Iain, you've mentioned your view on the court's approach in the future, and also, Anna, your opinion beyond the litigation process. But just coming back to you, Rebecca, maybe do you want to just say one or two words on your view of what it means from the institutional side of things, and about cost, the fixed cost package?
Yeah, so I think very quickly, because I know we're short on time, I think my headline point here, I talked already a little bit about the responsibility that institutions are going to have, bearing in mind that there's a likely expansion of ADR. And I think it's fair to say that the fixed costs are going to be particularly important, because Iain touched on complicated potential ADR processes that may have very large numbers of people attending. So obviously, if the parties engage in an ADR process and invite barristers, solicitors, experts, and they go for a very long and very structured process and perhaps pay for an expensive venue, that can all add costs. So I think a fixed price package like we offer at LCAM is going to be really important. I think, as Iain said, sometimes you can engage in ADR without any cost whatsoever. But I think if you're going to use a neutral, it's important that it's cost effective for the parties, so it doesn't become an obstacle in itself to engaging in ADR.
Thank you. Well, I think that I have one question where Iain might be able to start, and I suppose that Anna and you can expand, is a question from Christopher saying that, is there any case law on late advice of the existence of a complaints process to a complainant? A frustration I have observed in the case of internal complaints processes is that so few in an authority seem to know about it at an early stage, and it's almost as if it is made up as dispute proceeds.
There aren't any authorities as far as I know, but there's a great deal of precedent, because every one of my opponents raises all sorts of objections to the complaints process, and whether you raise it at the beginning, the middle, or even after litigation's opened, there is an objection of some sort, because they can say things like, well, it's too early, we haven't got the papers. Of course, you can always get the papers through a subject access request, or they can say, well, we've incurred costs now, it's too late, or it's not independent, or it's too, the parties are too far apart. There are all sorts of objections, but generally, I've done lots of cases in which the court has agreed that there should be either a stay or even a strikeout. And in fact, I did one in the Court of Appeal in 2021 called Hockett against Bristol City Council, in which Lord Justice Bean, David Bean, gave a judgment on a single piece of paper of refusing permission to appeal, and saying, in a case like this, where the claimant hasn't tried the internal complaints process, hasn't used a subject access request to gain information and documents, it just seems like this is a costs generating exercise. And he dismissed the claimant's appeal against a refusal from the courts below to award, or rather to order, a pre-action disclosure. So in other words, there are precedents, but they're just few and far between in the Court of Appeal and below in the first instance, and on appeal in the county court. I've got lots of precedents, but it's a difficult thing to do, to get the cases to the Court of Appeal. Obviously, in the face of Halsey as well. So we had Halsey to deal with previously, but we'll see in May what happens. I would have thought. I haven't got anything else to say, I don't think.
Thank you. I suppose, given the time now, I would probably thank you everyone for joining the webinar, and I hope you enjoyed it as much as we did. And please, if you could complete the feedback survey that is provided in the Q&A section, that would be really great. Thank you also to our panel on behalf of LexisNexis. Your contribution has been very much appreciated, and I hope you all have a lovely day. Thank you very much.
Thank you so much.
Thank you.
Goodbye. Thank you, everyone.
Bye-bye.